Let us continue our discussion. In today's session, we will discuss the concept of partner and designated partner. Section 5, 6, and 7. All these section numbers are important for exam. The concept is also important. As usual, my main aim is to help you learn the entire act in the lecture itself. So I have made handwritten notes for the concept of partners as well as designated partners. So we will discuss it from my handwritten notes first, and then we will read it from the textbook. Okay, let's get started. Now, the persons who start or incorporate the LLP, they are known as partners. These partners, they bring in their capital contribution. They manage, they do the business together in LLP. So persons are known as partners. Then who are designated partners? We discussed this in the previous lectures that there's no limit to the maximum number of partners. So what if there are 300 partners in LLP? The ROC wants to communicate because there was a default in filing the statement or returns. So he went to a partner. He said, "No, no, I'm not in charge. Go to the other one." He went to the other person. He said, "No, no, no, I'm not in charge. Go to the third one." So he went to all the 300 partners and he did not find anyone who took the responsibility of filing those returns. So don't you think that there may be some compliance issue when there are many partners? So we ask certain persons to take the responsibility of filing the returns or filing the statement of accounts, etc. with ROC. Such persons who are designated, it is your responsibility that they are given that responsibility. Such persons are known as designated partners. So let us discuss the concept of partners and designated partners. Partners are the concept is discussed under section 5. I'm not talking about the definition. Definition is given under section 2, clause Q. The concept is discussed in section 5. Who are partners? Section 2, clause Q. Yes, you need to learn this definition. You need to learn the section number also. So, section 2, clause Q defines partner. Now, partner means any person who becomes a partner in the LLP in accordance with the LLP agreement. So, if your name is written in the LLP agreement as a partner, then you are considered as a partner. So, partner means any person who becomes a partner in the LLP in accordance with the LLP agreement. They have used the word person. Now, this person may be either living person, natural person, or it can be an artificial person like a body corporate. So, they have used the word person. So, partner means any person. Now, this person may be a natural, that is, living person, or it may be an artificial person. Any person who becomes a partner in the LLP in accordance with the LLP agreement, your name is written as a partner, then you will be considered as partner of LLP. Who can become a partner? An individual and even a body corporate can become a partner. Body corporate, we had studied the definition earlier. Yes, in the beginning of the chapter, I had covered all the definitions. So there we had discussed the definition of a body corporate. So it means a company incorporated under the Companies Act. So any company incorporated in India, outside India, LLP incorporated in India, outside India, they are all body corporates. See, corporate means it has a separate legal status, perpetual succession, and it is clothed with legal personality. It is given rights to enter into contract in its own name. It is a body corporate. So an individual means natural living person, or a body corporate, artificial person, can become a partner in LLP. However, the following individuals cannot become a partner in LLP. So let us go through that also. An individual shall not be capable of becoming a partner if he is found to be of unsound mind by a court having competent jurisdiction. Now, every court is given its own jurisdiction. Like you are in Mumbai and in a particular area like Western Mumbai. So, yes, your particular area will be under this court. So, any court having jurisdiction declares you as an as an unsound person. Now, unsound means he is no longer capable of contracting. So, such person cannot become a partner. If he is found, it means yes, it is confirmed that the person is of unsound mind by the court having competent jurisdiction, then that person cannot become a partner. See, the words are very important. Any individual. Now, the word any, it means that any person, but we are clarifying that the word any will not include a person who is found to be unsound. Any person who is an undischarged insolvent. What is the meaning of undischarged insolvent? It means that his debts are not yet satisfied. We are in the process of paying off his debts, how much ever we can. Now, let's say, for example, that a person is declared as an insolvent. He has 5 lakh rupees of debt. His assets are of 3 lakh. Okay, so he has debt of rupees 5 lakhs. He has assets of 3 lakhs. We are trying our best to pay off the liabilities, how much ever we can. But till now, the process is not yet completed. So the debts are not yet satisfied. Ma'am, he is unable to pay the debts. That is why you're declaring him as an insolvent. No. So what will happen if he is not able, like here it is so clear, his assets are worth 3 lakhs, he has debts of 5 lakhs. So there is a deficiency. That is why he is declared insolvent. See, he is now undischarged because we are still in the process of selling the assets, paying off the liabilities. Later on, once we realize that yes, this is what we can pay, we cannot pay anything more than this, then ultimately he will be declared as bankrupt. Okay, then in that case, he will be declared as bankrupt. So undischarged means his debts are not yet satisfied. Okay, we are in the process of satisfying his debts. So if you want, you can write over here, the debts are not yet satisfied. Okay, we are in the process of satisfying the debts. A person has applied to be adjudged as an insolvent, but his application is still pending in the court of law. You cannot declare yourself to be insolvent. Arey, listen, everyone, from tomorrow I am insolvent. You need to apply to the court. The court will judge you. They will declare you as an insolvent. And once you are declared insolvent, then you cannot contract. But he has applied for insolvency. He may be declared as an insolvent. So he cannot be appointed as a partner. What if he is declared as an insolvent? He cannot be a partner. He has applied. His application is still pending. But what if it is approved? What if he is declared as an insolvent? He cannot take that risk, no? So as of now, although he has just applied but he is not declared, but what if he is declared as an insolvent? No, no, no. You are not capable of becoming a partner. You are incompetent to become a partner. You are not capable of contracting. So he has applied, but his application is still pending. Even then, we will not allow him to become a partner. So I hope you have written this. I'm very sure you must have paused the video and taken down notes. If no, then I'll show it to you. Please pause the video and write it. Done. Okay. Let us read it from the textbook, and there are a few other points also. As per section 2 clause Q, important section. Partner in relation to an LLP. I simply admire the lawmaker. See, the word partner can also be defined in context of Partnership Act. But here, section 2 clause Q is very clear. We are defining a partner in context of, in relation to LLP. So this definition should be read keeping in mind LLP Act. So in relation to an LLP, in the context of LLP, any person who becomes a partner in the LLP in accordance with the LLP agreement will be considered as a partner. So this definition is defining partner in the context of, in relation to LLP. Any individual. See, although they have used the word any, but that any will not include a person who is found unsound. It will not include undischarged insolvent. He has applied, but and yeah, he is declared insolvent, but as of now, his debts are not yet fully satisfied. he has applied to be adjudicated as an insolvent, but his application is pending, he cannot become a partner. You can even appoint a body corporate. You can admit a body corporate as a partner. The following persons can become partner in LLP. Yes, an individual can become a partner in LLP. Now, this individual includes resident Indians. Resident means they are staying in India. It also includes a non resident Indian, NRI, overseas citizen of India, OCI, as well as foreign nationals. So you are an individual. It doesn't matter whether you are an Indian citizen, whether you are a foreign national, whether you are a non resident Indian. Now, what is the difference between NRI and overseas citizen of India? I have a small note for you. Non resident Indian, it means he is a person who, let's highlight the keywords. He resides out of India. It means he stays out of India, maybe for business purpose, for employment purpose, or any other purpose. Who is an overseas citizen of India? Overseas means he is a foreign national but of Indian origin. He is a foreign national but of Indian origin. However, overseas citizen of India, this status provides him the right to stay and to work in India indefinitely. He's of Indian origin. So he is a foreign national but of Indian origin. Now, this overseas citizen of India status provides him the right to stay and work in India indefinitely. Okay. So, non resident and overseas citizen of India, yes, they can become partner. Do you want to write this? All right, I'll wait for you. All right, done writing. So, individuals, including residents, non residents, residents, non resident Indians, overseas citizen of India, foreign nationals, limited liability partnership. Yes, LLP is a body corporate. It is a separate person in the eyes of a case of contracting. So, one LLP can become a partner of another LLP. Companies, including foreign companies, we know the definition of foreign companies. It is a company which is incorporated outside India, but it is having a place of business in India. Foreign LLP. Foreign LLP means it is an LLP which is incorporated outside India, but it has a place of business in India. Foreign LLP can become a partner in Indian LLP. We had discussed this. Limited liability partnerships incorporated outside India. It is incorporated outside India, may not be having a place of business in India, but it is a body corporate capable of contracting. It can become a partner. So, limited LLP incorporated outside India is a body corporate. And we had just studied that a body corporate can become a partner in LLP. Foreign companies, okay, foreign companies, they can become partner. However, a cooperative society and corporation soul cannot become a partner in LLP. They are not even body corporate. They are not individuals. They are not even included in the definition of a body corporate we had studied. If they are neither individual nor body corporate, they cannot become partner in LLP. So they are not an individual. They are not even a body corporate. Therefore, they cannot become a partner in LLP. All right. In case of, there is a small note. See, there are asterisks over here. Now, what does that mean? In case of, we will first highlight and then discuss it. In case of introduction of capital, okay, you have introduced capital and become a partner, or you have acquired the existing stake in LLP, you have acquired the stake of a partner in LLP by persons resident outside India. I'm not reading what is given in the bracket right now. I'll read it later. In case you have introduced capital, in case you have acquired an existing stake in the LLP. Who is doing all this? Person is resident outside India. All right. You are resident outside India and you are investing money in Indian LLP, then the foreign direct investment compliances, FDI compliances, will have to be undertaken by the LLP in which the investment is made. Who will carry out these compliance procedures? The compliance will be taken up. It will be undertaken by the LLP. So the LLP will have to comply with the FDI compliances. When will they have to comply? When there is introduction of capital or acquisition of stake by a person resident outside India. But it will not include, okay, persons will not include NRI, OCIs who are investing on a non repatriation basis. Okay, they have written other than, it means it will exclude NRIs and overseas citizen of India who are investing on non repatriation basis. Now, in order to understand non repatriation base, we have to first understand what is repatriation basis. So I have a note for you. Now, why we are writing these notes? So that it is easy for you to understand now, and also later if you forget, you can always refer these notes and you will be able to recall the concept. Now, no, first let us understand what is the meaning of repatriation basis. Repatriation means people will invest and then take that money from India to the place where they are now staying outside India. And NRI, okay, NRI means he is non-resident Indian, he is staying abroad. He invests the foreign earnings in India. If he is investing on repatriation basis, it means that the funds can be transferred back to the NRI's country of resident. So they do it through different accounts. So he has invested money in India, but he is going to take it from that account to his country where he is currently staying. So funds can be transferred back to the NRI's country of resident by converting them from Indian rupee to foreign currency at any time. That is repatriation basis. Non-repatriation is actually the opposite of repatriation. What is the meaning of non-repatriation? Non means that money when invested in India will not be taken back to his place of residence or country of residence. Non-repatriation is actually the opposite of repatriation. Non means that the money or funds, they cannot be transferred from this account outside India. So it is considered as if it is a domestic investment. It is not considered as a foreign investment. Therefore, FDI compliances are not required. It is not considered as foreign investment because that money is going to stay in India. So you are bringing money into India. It is on non-repatriation basis. It means that the money or funds will not be transferred from this account outside India. Investment on non-repatriation basis will be treated at par with the domestic investment. Therefore, it is not considered as foreign investment. Hence, FDI compliances over here will not be required. I'm talking from the point of view of LLP. Now, let us take down notes. Please write all this in your notebook. Done. Okay, write this also. Done. Let us read it now. So that was about the persons who can become partners. Will this be asked in the exam? Maybe asked in the exam, but you're not expected to write the explanation. This is just for our reference. Minimum and maximum number of partners. Let's discuss minimum number of partners. Section 6. How many partners required? Yeah, we need minimum 2 partners. Yes. Is there any limit on the maximum number of partners? There's no limit on the maximum number of partners. Okay, there is no upper limit on the maximum number of partners. But yes, every LLP will have at least 2 partners. Now, this number needs to be maintained throughout the lifetime of LLP. Do you remember we had discussed something similar in Companies Act also? The minimum number in a private company, that is two members, and minimum number of members in a public company, that is 7. That needs to be maintained throughout the lifetime of the company. Similar requirement over here also, because what is LLP? It is nothing but a combination of partnership and company form of business. So yes, you will have at least 2 partners, and you can write over here that this minimum number, this number needs to be maintained throughout the lifetime of the LLP. Okay, this number needs to be maintained throughout the lifetime of LLP. Let's say, for example, that there were 5 partners in LLP. They were traveling by bus. Bus met with an accident. Only one survived. Now, can this single partner carry out business in partnership in LLP? That's not possible. This is not a partnership. Partnership means we need at least 2 persons, right? But we still realize that this is a tragedy. It's a tragic situation losing all your partners. Sometimes they argue and all the partners leave and he's left alone. See, you cannot continue business in LLP on your own. But we know that this is a very tragic situation. We will give you a time limit of 6 months. In these 6 months, you need to introduce one more partner. Okay? Reinstate the number to 2. We will give you time limit of 6 months. If you fail, okay, if you fail, then your liability will become unlimited. It means you will be personally liable. You're personally liable. For all the debts? No, 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 no. You will be personally liable for all the debts after 6 months. Okay? Personally liable for all debts contracted after 6 months. So, yes, in this case, the surviving partner, he is very much aware that he is the only one left now. So, he will start being personally liable for all the debts contracted after 6 months. This can also be a valid ground for winding up by the tribunal. So, later we are going to study that in case the number is reduced below the minimum and the LLP continues to do business even after 6 months, this can be a valid ground for winding up by the tribunal. So, you can say in this case, it may be wound up by the tribunal. Okay, it may be wound up by the tribunal. Let us now discuss everything about designated partners. Designated partners is discussed under section 7. First, let us understand what is the role of designated partners and why do we need designated partners. Now, let me use DP. Otherwise, I'll have to keep on repeating designated partners again and again. So, I'll call them as DP. Okay, designated partners, DP. Now, imagine having 300. Okay, imagine having 300 partners in LLP. Now, if there are 300 partners in LLP, if there is some issue, ROC approached one partner. He said, no, this is not my work. He sent him to another. That person sent him to another partner. He went to 300 different partners and nobody owned it. So, can I say that in this case, we need someone, we need to designate that authority to someone. You are responsible for compliances, filing of documents, statements, returns, etc. The person who is given that responsibility, what is the meaning of designation? Designation means that person has the authority. Your position has given you the authority to do that. It is your responsibility. That partner who is in charge of compliances is known as designated partner. Now, designated partner is responsible for the compliance obligation of LLP, like filing of documents, return statements. Now, what return will be filed by LLP? LLP needs to file annual return. Okay, annual means it needs to be filed every year. So, we need to file the annual return. Okay, LLP is also required to file the statement of accounts and solvency. Okay, so filing of this should be on time and every year you need to file it within the time limit. If it is not done, then the designated partner will be held liable. So he will be responsible for all the penalties, etc. imposed on LLP. The designated partner shall be responsible for any violation in compliance of these stated requirements. So if there is any violation, we will hold the designated partners liable. DP shall be liable for all the penalties, punishments imposed on LLP for contravention of those provisions. The reason behind that is that LLP doesn't have a mind of its own. LLP is not someone who is deciding to who has gone for these non-compliances. The DP is in charge and they have not fulfilled their obligation, they will be held personally liable. So can I say that this is a position of great responsibility? Yes. So the designated partner shall be responsible for any violation in the compliance of these stated requirements. He will be held responsible for all the penalties. Please pause the video and copy this in your notebook. Next, let us discuss who can be appointed as the designated partner. Now, what are the requirements of a designated partner, or can I say that who is competent to be appointed as a designated partner? So, law requires that at least two persons should be designated partners. Do we need to appoint them separately? No. They can be appointed from among the partners themselves. So can I say that designated partner, we need at least two? At least two. Okay. And they must be individuals. Individual means they must be natural, living persons. What is the logic behind this? The DP is in charge of compliances, whether the documents are properly filed or not, the returns are prepared and filed or not. How can an artificial person judge whether the compliances are fulfilled or not? How will an artificial person take the decision of what is to be entered, what amount should be entered, whether there is any delay, so how much penalty we will have to pay? There are different data requirements. So only a living natural person can judge what is to be written in that column, right? So law says that a living natural person is only capable, only that person is capable of taking a decision as to as far as compliances are concerned. Therefore, only individuals can be the designated partner, and at least one must be a resident in India. Okay, at least one of them must be a resident in India. Now, because the word resident is used, it is inevitable that we define it. So, a resident means person who stays in India for at least 120 days during the financial year. Ma'am, all this is written in the notes. Why should we copy this? Why are we writing this? Writing practice will help you to memorize the provisions in the lecture itself. So these are tried and tested techniques. Please don't be lazy. Copy everything, whatever we are writing. Write at least once. Get into the habit of making your own notes. Writing everything in the lecture itself. Yes. So designated partner, I need at least two. Do we need to appoint them separately? No. You can choose any of the partners to also act as designated partners. Okay, so we will select them from among the regular partners only. Ma'am, you have mentioned that all designated partners need to be individuals, but it is not compulsory. No, we can also have body corporate as our partner. Now imagine a situation where the LLP is formed by two body corporates. Okay, so we have ABC Private Limited and PQR Limited. So they are body corporates. They can become a partner in LLP. What if the LLP is incorporated by two body corporates? Then who will be the designated partner? They are not individuals. In that case, students, these body corporates will appoint nominees. So nominee of ABC Private Limited and nominee of PQR Private Limited. These nominees will become the designated partners. They are individuals. Ma'am, will this residency requirement apply to these nominees? Yes. Residency is checked for the individual. So if these two nominees are appointed as the designated partner, then the residency status will also apply to them. So at least one of them must be resident in India, at least one. What is the logic behind this requirement? Why are we insisting that at least one of them should be in India? This logic is very similar to directors. At least one of them should be in India. So if there are certain compliance issues, if ROC wants to communicate, at least one of these designated partners should be in India. How will we communicate if all the designated partners stay out of India? So for better compliances, we require at least one designated partner to be in India. Now there are various combinations which can happen. I discussed one of them, that both the partners are body corporates. And in that case, we discuss that nominees will become the designated partner. Ma'am, what if I have one individual? Okay, one individual and one body corporate. These are my regular partners. Or we have other body corporates. There's just one individual and other are body corporates. Then what will happen in this case? See, our preference will always be given to the individual. So he will automatically become the designated partner. He cannot escape. And you can choose a nominee of any of these body corporates. I need at least two. So maybe there are other body corporates. Any one of them can say, yes, I will give one nominee. You can become the designated partner. So I have one individual and one nominee. Ma'am, we need at least two. So can we have 3, 4, 5 designated partners? Yes, there is no limit. In fact, all the partners can be designated partner. We are still going to study the other combinations. So let's say, for example, that I have an LLP in which there are only individuals. Okay, so let us take different combinations. Let's say that Mr. X and Mr. Y, okay, these are two individuals. They have formed XY LLP. Okay, they have formed XY LLP. There are two individuals. Ma'am, there are only two individuals. Then who will be the designated partner? Both will be the designated partner. So in this case, both will be designated partner also. All right. What if we have, let's put this as 1, 2, and 3. So in the first situation, both were body corporates. In the second situation, we had one individual and other body corporates. So we said, please give preference to the individual. So that individual will by default be the designated partner. And from the other body corporates, you can have any one nominee as the designated partner. Can we have two nominees? Yes, at least two designated partners. So there it means that you can have more than two also. Okay, now I have three partners, X, Y, and Z. Okay, they are three partners. They have formed LLP, X, Y, Z, LLP. So who will be the designated partner? I'm considering the minimum, okay? X and Y can be designated partner. Y and Z. So I'm giving you various possibilities. X and Z can be the designated partner. All X, Y, Z can be designated partner. Okay, so this is another combination. One very interesting situation. Okay, very interesting situation. XYZ Private Limited, PQR Limited. As of now, they are the regular partners. Irregular partners. Normal partners, regular partners. Later, okay, now in this case, the nominee of both shall be the designated partner. But later, they admitted an individual as partner. We have found an individual. Yes, yes, yes. This individual will become the designated partner. And any one of these nominees may continue. Okay, so when we get an individual, then yes, preference will be given to that individual. That individual will become the designated partner. Okay, so we want an individual. It's not compulsory. These are just various possibilities that I am discussing with you. All right, so later an individual is admitted, so that person will become the designated partner. Do you agree with me that the position of a designated partner is of utmost responsibility? So these partners are actually very scared. They discuss among themselves that we cannot take so much responsibility every time. See, in case something goes wrong, then penalty will be imposed on us. So everybody is scared of continuing this responsibility for a long period of time. So we have come up with the solution of rotation. So they have decided in the agreement that for the first 2 years, A and B will be the designated partner. For the next 2 years, C and D will be the designated partner, and for the other 2 years, E and F will be the designated partner. So it means that every person will get to be the designated partner some or the other time. So for the first 2 years, A and B are the designated partners, C, D, E, F are relaxing. Then they will relax. It was a very tiring year. And C and D will take up the responsibility of designated partner. Then for the next 2 years, E and F. So this is a rotation, and in this case, every partner will get the chance to become a designated partner. So these are the various combination, students, that I wanted you to be aware of. Let us read this from the textbook. Every LLP shall have at least two designated partners. So I need at least two. There can be more than two also, but I need at least two. These should be individuals, and at least one of them shall be a resident in India. At least one of them should be available for any communication issues, right? The designated partners shall be responsible. They shall be responsible for all the acts and matters required to be done by LLP. So they are responsible for all the compliances, filing of documents, return statements, etc. The term resident is also defined. Resident in India means a person who stays in India for a period of not less than, it means at least 120 days. At least 120 days during the financial year. Then that person is a resident. In case of LLP in which all partners are body corporates, all are body corporates, or maybe in which one or more partners are individuals and body corporates. Okay? Either all are body corporates, or maybe there's one individual and another body corporates. Then the nominees of the body corporate shall act as designated partner. At least two individuals should be the designated partner, or the nominee of body corporate will be the designated partner. Okay. So what they mean to say is that only an individual can be a designated partner. So either that person or nominee of the body corporate, they can be the designated partner. They have also given you examples. LLP has three partners, one individual, Mr. X, and we have two body corporates. Okay, two body corporates, Messrs. XYZ Limited and ABC Limited. We will give preference to the individual. So, Mr. X, you are a designated partner. Okay, Mr. X. And from the remaining two body corporates, we can choose any one nominee because we need at least two designated partners. So, any one nominee. Ma'am, can both suggest nominees, and can we have three designated partners? Yes, you can have three designated partners also. An LLP is named SMY LLP. It has three partners: SI Limited, MIS Limited, YI Private Limited. There is no individual as a partner. All right, no worries. The nominees of these two body corporates will act as the designated partner. There are 5 partners in the LLP, Indian Helicopters LLP. Mr. A non-resident, Mr. B non-resident, C is resident, D is resident, E is also resident. See, we need at least two designated partners. Out of these two, at least one must be resident in India. So you can have an LLP, but you need to ensure that either C, D, or E should be the designated partner. Okay. So if A and B are designated partner, that is not going to serve my purpose. I must choose at least one out of C, D, or E to become the designated partner. So if A and B are designated partner, it will not serve the purpose. At least one of them should be out of C, D, or E. How will you become a designated partner? I have a beautiful note for that also. How will you become a designated partner? Check the incorporation document. What is incorporation document? This is the document which we had filed to incorporate the LLP. Check the incorporation document. It will specify the name of designated partner. So if the incorporation document specifies the name of the designated partner, then that person is the designated partner. Such person is considered as DP on incorporation. Or it states that each partner will be DP from time to time, that is rotation. So I discussed with you that for the first 2 years, A and B, for the next 2 years, C and D, for the next 2 years, E and F. So every person will get an opportunity to become the designated partner. It also means that every partner shall at some point of time become the designated partner. So it states that each partner shall be DP from time to time of LLP. So either the name is given or it simply states that every partner will become a designated partner from time to time. If nothing is specified in the incorporation document, then check the LLP agreement. The LLP agreement will specify a person who either becomes or how they will cease to be a designated partner, that may be written. So a person may either become or cease to become a designated partner in accordance with the LLP agreement. So check the agreement. Now it may mention that A is the designated partner for 3 years. After that, he will retire. He will never become a designated partner. See how what is written in the LLP agreement. So sometimes the provision of rotation may be given. So we don't know. Nothing was mentioned in the incorporation document. So then you check the LLP agreement. How a person can become and cease, the procedure will be given in the agreement, so in accordance with the LLP agreement. So we discussed two ways in which a person can become a designated partner. We will check the incorporation document. If nothing is specified over there, then we will check the LLP agreement. All right. These are the legal requirements. These are the filings and how you need to communicate the name of the designated partner to the ROC. See, ROC should be aware of who is the designated partner, who should the ROC approach in case of any compliance issues. So we need to inform the ROC about the LLP, about the designated partner. Now the DP will first give his consent to act as the designated partner. It is very similar to directors. You cannot just mention that Mr. Mukesh Ambani has agreed to be the director of my company. ROC will say, give me his consent letter. Has he really agreed to become a director? Similarly, you just cannot write the name of a designated partner. Array, ROC will keep on searching who is the designated partner. Let us write some fictitious name. So none of us will be responsible for compliance. ROC is very smart. Show me his consent letter. Does he have a DIN? I will check. I will check whether that person has a DPIN, whether that person actually exists or not. So you just cannot write any person's name as the DP. If we need his current consent also. Is he really aware that he is the designated partner? Has he agreed to accept that additional responsibility? This consent will be filed with the ROC in Form 9. Okay. So in Form 9, I'll just write it properly. Form 9. Okay. Now, the designated partner will give prior consent to LLP. This consent will be in Form 9. So, designated partner will give his consent to the LLP. The LLP shall, within 30 days of his appointment, file with the ROC such particulars of the designated partner. Particulars means giving information, the name, address, DPIN, everything will be informed to the ROC. Let's read it again. The designated partner, I have also highlighted the steps. The designated partner shall give prior notice to LLP. The LLP shall, within 30 days of his appointment, file with the ROC the particulars, information about the designated partner. The designated partner will have to obtain a DPIN from the central government. Now, what is a DPIN? It's nothing but an identification for the designated partner. It's very similar to your director identification number. DIN. Now, DIN is Director Identification Number. Now, what is the importance and what is the use of DIN? See, you visit the website of MCA, you enter DIN of any director. You will get a list of all the companies in which he is a director. So, if you enter the DIN of Mr. Mukesh Ambani, ma'am, how will we come to know the DIN? It is public information. It is publicly available. Just Google Director Identification Number of Mr. Mukesh Ambani. So you enter the DIN in the website of mca.gov.in. Okay, visit mca.gov.in, enter the DIN number, and you will get a list of all the companies in which he is a director. So it is giving information. So we will come to know which all company he is a, because there is a limit to the maximum number of directorships a person can hold. Please note, students, DIN is person specific and not company specific. What is the meaning of this? It means that every person will be given a number. Now, if I am a director in 4 companies, I will give each of them my same director identification number. So this is person specific and not company. Each company will not give me a DIN. Okay. DIN is personal. I also personally have a DIN. I'm a director in 2 or 3 companies. Then each of those companies will be listed under my DIN. Ma'am, I already have a DIN. Do I also need to obtain DPIN if I become a designated partner? Answer is no. If you already have DIN, then you do not apply for DPIN, because I told you DIN is person specific. Let us maintain records under one number only. So if I want to become a designated partner and I already have a DIN, then I don't need to obtain a DPIN. Okay. So if I have a DIN, no need for DPIN. Ma'am, I have a DPIN. I have a DPIN. Let's talk about the reverse. I was a designated partner, so I already have a DPIN. Then no need for DIN. So if you become a director, okay, first you were a designated partner in LLP. Then you became a director in a company. Then you can use the same DPIN. Ma'am, by mistake, I have a DIN as well as DPIN. You can't have 2 numbers. Your DPIN will automatically stand cancelled. Then if I become a designated partner in LLP, your DIN will be quoted as DPIN in LLP. Okay, so if you have a DIN, no need for obtaining DPIN. If you have a DPIN, no need to obtain DIN. If you have both, your DPIN will automatically stand cancelled and your DIN will be stated as a designated partner identification number. Now, please note, students, if I enter the director identification number on the website of MCA, I initially informed you that all the companies in which we are director will be listed. Now that I have also discussed with you that if you already have a DIN, no need for DPIN, can we now conclude cumulatively that if I enter the DIN of any person in the website of MCA, I will not only get a list of the companies in which he is a director, but I will also get a list of the LLPs in which he is a designated partner. You go and do that in the website of MCA. Enter the director identification number of Mr. Mukesh Ambani. You will get a list of all the companies in which he is a director and all the LLPs in which he is a designated partner. The reason is it is person specific, not company or LLP specific. So because it is person specific and you are using this interchangeably, okay, you are using this, like if you have one, then both the places you will use the same number. Because we are using the same number, the list of all the companies and the LLPs in which I am either a director or designated partner respectively, that list will be shown. So that is the use of director. It helps to identify. that in how many companies is this person a director. There is a limit to the maximum number of directorship. Is it within the limit? That check can be kept only when we have a record, and this is the best way to maintain record. You will not be able to incorporate a company or LLP unless you obtain DIN or DPIN. That incorporation will not happen only. Okay, so that was the story about DIN, where we had did that. Let's go back to the notes. So every person will have to obtain a DPIN. Okay. If the incorporation document specifies the person who are the designated partner, then such person will be the designated partner on incorporation. Or it may state that each of the partner from time to time of LLP will be the designated partner, then every partner will be the designated partner. This is nothing but rotation. So each partner will get an opportunity of also becoming a designated partner. Sometimes, in accordance with the LLP agreement, yes, any partner may become, or he may either cease to become designated partner in accordance with the LLP agreement. So the procedure of who will be considered designated partner, when you will cease to be, stop being one, all that is mentioned. Individual will become a DP only after he gives his prior consent. And what is the form number? I had informed you that consent will be given in form 9. As soon as the DP is appointed, within 30 days, we will give information of all the particulars of that DP to LLP. Each of them will also have to obtain a DPIN, that is direct designated partner identification number, from the central government. Now, how to obtain DPIN? Because it is very similar to DIN, we say use the same procedure. So the provisions of section 153 to 159 relating to DIN of the Companies Act shall apply mutatis mutandis for the said purpose. This is given in your note also. From there I had diverted, I think, to the explanation. So yeah, here also it is given. How will you obtain DPIN? By complying with the provisions of section 153 to 159. See, we had discussed earlier that if certain terms are mentioned, but the provisions are not given in the LLP Act, you can use the same provisions that are given in the Companies Act. So same procedure, but it will apply mutatis mutandis. Now what is the meaning of this? It means with consideration of the respective differences. What differences? See, in the Companies Act, in these sections, we must have used the word director. But when you apply the same provisions to LLP, can I say director? No, I will have to use the word designated partner. So instead of director, use the word designated partner. Instead of company, use the word LLP. So make the necessary changes, but the provisions will remain the same. So we will apply the provisions mutatis mutandis by making the necessary changes. So with the necessary changes or with consideration of the respective differences. What are the liabilities of designated partner? He is responsible for all the acts, matters, things which are required to be done by the LLP. Can I say he is responsible for compliances? We had written this in my handwritten notes. He is responsible for filing documents, returns, statements, reports, etc. He is liable for all the penalties imposed on LLP. Last part, changes in the designated partner. Suppose he dies, or maybe retires, or becomes insane. He's no longer capable of continuing as a DP. How will he ensure that the compliances are in order? Vacancy is created. Then within 30 days of this vacancy, LLP shall appoint another designated partner in his place. Did you inform the ROC? No. Then within 30 days of appointment, LLP will file with the ROC particulars of new DP along with his consent to act as DP. Consent is in form 9. So the designated partner, in case he dies, he becomes insane, or he is retiring, then within 30 days of this vacancy, LLP will appoint another DP, and within 30 days of appointment, they will file the particulars of new DP with the ROC along with his consent to act as designated partner. In case the designated partner is not appointed or there is only one DP, then each partner will be considered as a designated partner. So if there is no DP or if there is only one DP, each and every partner will be considered as designated partner. So please copy this in your notebook. Done. Very good. Now, whatever I have discussed is mentioned here. Each and every point is properly mentioned. Okay. So, students, with this, we come to an end of designated partner. In my next session, I will revise partner and designated partner. You also revise till then, and then we will continue with the other concepts.